And then the last thing is Tosha Heavican. So she is from Hightower Reff Law, and she's going to discuss special needs trusts and how they work and what they can do for you. And she's a lawyer and a lot smarter than me, so I'll just let her explain it.
Very good, thank you.
I am sure that is not true, but everybody has their strengths. So let's put it that way. So just a little bit about me. So my name is Tosha. I am an attorney licensed to practice law in Nebraska and Iowa. I graduated law school in December of 2011 and have been practicing in private practice since then. This is my second year with Hightower Reff Law. I was with a different firm prior to that. I actually live in Council Bluffs, Iowa. I grew up in Council Bluffs. I went to Doane College in Crete, Nebraska for my undergrad, and I went to the University of Nebraska College of Law for my law degree, and have just kind of stuck around here. So I'm familiar with a lot of the places that you guys have mentioned, and yep.
Sorry to interrupt you. I forgot to tell everybody that you were actually the lawyer that set Nebraska Ataxia up as our own 501c3. So the reason Nebraska Ataxia exists is because she did all the paperwork. Way to go, Tosha. Sorry,
Yes,
I forgot that.
That was so many years ago, Linda, but yeah, it was a fun project, and I was happy to be a part of it. And it's been, you guys have had such a journey since then. I've kind of followed it, and I work with Susan Reff, who's a good friend of Skippy and Linda's, and so I've been able to kind of watch your guys' growth, with the foundation and stuff, and so it's been really great. A little bit more about me. I'm married. My husband is from Schuyler, Nebraska, which is close to a few of the towns that you guys have mentioned, and I've got 2 kids. So when I'm not being a lawyer, I'm at home being a mom and a wife. So with that, I don't know, Skippy, if you have a way to share where the PowerPoint slides come through okay?
Yeah, you can just do a share screen on the bottom there. I gave you access to do that. Did you actually send me PowerPoint?
Yeah,
I have the mic to share the screen with me.
Okay.
Yeah, if you could do it, because it's on my work computer, and I'm not at work.
You have
so.
I send them.
So do you hear me, Skip?
Yes, you can go ahead and share.
Okay.
And of course, this is meant to be more of a conversation than me talking at you. So I'm going to try to. My thought process as I was putting together these slides is that I really want to give kind of a basic understanding of trust law and then how it specifically relates to special needs trusts, or what we call SNTs. And there will definitely be time at the end for questions, but as things come up, let's talk about them, because that's always, in my opinion, better to do it in the moment than, when you're thinking of it and that sort of thing. So my information is on here, just so you kind of have it in terms of my email and phone number. So if things come up, if you have questions, of course, Linda also always knows how to get a hold of me and that sort of thing. So, and then with that, if you want to go kind of to the next slide. So when we're talking about a special needs trust and kind of what the functions are for this type of a trust, the key component that we are always looking at when we're thinking about special needs trust is going to be, how do we preserve eligibility for clients who are going to be needing what are called need-based benefits, okay? So the idea is that we set up a special needs trust in order to maximize entitlement and eligibility for beneficiaries, typically who are receiving either SSI or Medicaid entitlement benefits. And by setting up an SNT, we can extend funds that they are receiving. For example, if a person with special needs would be receiving a settlement fund, or they would be receiving funds in the future, maybe as an inheritance or something like that, and we can talk about those in a minute. But if you have a situation like that where somebody who is otherwise on needs-based benefits and they're going to be receiving some type of a lump sum of money without outside planning, that money that's coming in is going to kick them off their benefits. And that's not typically what's in their best interest or what we would want to have happen, right? So we have to look at what is the potential options that we have for planning for this money so that we can receive the money and maintain benefits, right? That would be the ideal scenario. The other thing that we look at for special needs trusts is that they often provide restrictions on spending in order to prevent an invasion of the asset. And so in that way, we preserve benefits for the person while also having this pot of money that can be spent on things for the beneficiary of the trust. So when we have this pot of money, and we're going to talk about the structure here in a minute, but the special needs trust allows for specifically tailored guidelines for how assets can be maintained, what the money can be used for, and it would be dispersed by providing for management and supervision of the assets in order to maintain principal. So for example, maybe we're only using income depending on how much the money is, so that we can grow it. And in that way, this money would have some longevity, right? So it can last for a long time and provide for supplemental needs for a person who's otherwise on benefits. So in terms of kind of logistics, I guess, for lack of a better word, you know, what does this look like, right? So if a client comes in and they say, okay, like for example, the most recent client I worked with was a lady who has a son he's an adult disabled person with special needs. And she says, when I die, I would like to benefit him in some way with my estate, but he also is on SSI and Medicaid. So how do we do that? And so we look at creating a trust document, a special needs trust. And I like to think about this in terms of when you're creating a trust, we're going to create a bucket, okay? The trust is a bucket. And then we're going to put stuff in it. We're going to put stuff in the bucket. And the trust document is what says what happens to the stuff that's in the bucket, okay? So the trust document is going to be very specific about the types of assets that it can receive, when the assets can be paid out, who has the ability to decide when the money is paid out, you know, all of those types of things. What happens to the money if it's not all used before the person passes away, or what events would allow us to terminate the trust? You know, all those types of things would be included in the language in the trust document. And that's kind of step one as we create this document. And then everybody signs it, the trustee and the person who's creating it. That person is typically called the grantor or the settlor, okay? And then step two is funding. So by that I mean we're putting stuff in, whether it's we're funding it with a life insurance policy, maybe we're funding it with cash, maybe we're funding it with maybe it's considered a testamentary trust, meaning that we're not putting anything in it right now, but when I pass away, if I created the trust, when I pass away, it's going to receive all of my estate, right? So that would be considered a testamentary trust. And then the other big thing is that we're talking about who is the trustee going to be, and typically in cases when I've worked on more complicated planning such as this, we're going to involve that trustee at the beginning so that we can have a conversation with them and you can feel comfortable with them because they're going to be the person who's managing the money. So we talk with them about when can things be paid out, and under the Social Security rules, there's going to be specific parameters on what can be paid for anyway, but having a conversation with the trustee about what things are most important that should be paid for and that sort of thing. So in terms of kind of this process, we are looking at, when we're meeting with a client, we're looking at what are the facts of each case, right? So we have, every person's case is going to be different, okay? And that's where we have to look at, okay, what are the laws that apply and how do we make it work for that particular client? And so at the outset, we're going to be asking several questions. Number one is going to be, what government benefits are currently being received by the beneficiary? You know, are they receiving SSDI? Are they receiving SSI? Are they receiving Medicaid? Are they receiving veterans benefits? You know, all different types of programs that are out there. Number two is going to be, what government benefits will they receive in the future? Okay, so we don't have a crystal ball, but we try the best that we can to say, okay, what are potential things that we're going to be seeing in the future that we would maybe need to account for? And then number three will be, will the benefits from, for example, an inheritance, or if there's a structured settlement that they're going to receive, are those going to result in some sort of a disqualifying event for the beneficiary to continue to receive whatever benefits they are receiving? Okay. And then the fourth question, obviously, is there a way to preserve benefits by transferring the benefits into a trust? Okay. And we're going to talk about, there's some other planning tools that we can look at as well, and we'll talk about those today. So in terms of, once we kind of review those facts with the client and we have a good understanding of what does the picture look like, okay, then we're going to ask, within the benefits that they're receiving, which ones are means tested and which ones are not. And basically that boils down to, is there some sort of a financial component to the eligibility for the benefits? So there are tons of programs out there for benefits that people receive that would not be affected by a beneficiary receiving an inheritance or receiving money from a structured settlement or something like that. For example, Social Security Disability, which is SSDI, and I don't know who made up these acronyms because they're all very, very similar, and so sometimes it can be confusing. But SSDI is a federal program that's funded primarily with Social Security tax, and it's paid through employed individuals. And so those benefits are available for individuals who are aged, which are retired, they're blind or disabled, and they generally have worked 20 out of the previous 40 quarters. And so you have to have worked those that amount of time in order to potentially qualify. Basically, you've worked long enough, you've paid into the system, you're eligible to receive funds out of the system, okay? So typically, in order to qualify for that, you have to have a medically determinable severe impairment, which results in the inability to engage in gainful employment. Basically, you can't work because you are disabled. Now, again, these benefits, SSDI, they're not going to be affected by your ability to receive funds from an inheritance or something like that, because it's not a means-tested eligibility program. Okay, similarly, if you have Social Security survivor benefits or veterans compensation benefits, Medicare, unemployment benefits, you know, and this isn't an exhaustive list. There's all types of benefits out there that they aren't necessarily means tested, so it's not going to affect funds being received by the beneficiary, okay? So then we look at what types of programs are means tested, okay? And the two most common that people see are going to be SSI, so no D, SSI, and Medicaid. So SSI is a federal program that is funded from a separate trust fund aside from income taxes to assist individuals who medically or age-wise qualify for Social Security, but who are eligible for needs-based assistance based on low income or minimal resources. SSI recipients, usually they didn't have enough working quarters. So you know how under SSDI, we talked about if you work 20 out of 40 quarters, you would have some eligibility under that program. But typically SSI recipients don't have that work history. For example, if a person has been disabled their entire life, they wouldn't have been able to work, right? So they wouldn't have those 20 out of 40 quarters. So typically these are going to be people such as disabled children. So SSI recipients usually did not have enough working quarters to qualify for Social Security benefits are disabled children, have a Social Security benefit level not sufficient to satisfy federal poverty guidelines, or their need levels require assistance during the 5-month waiting period before you can qualify for SSDI. So, because there's a waiting period once you apply for those. There's going to be an income limitation. So, and every state is different. So you'll want to look in terms of the regulations for Social Security, because it's kind of a quasi-federal, quasi-state run system, right? So we have to look at both laws. We have to look at federal rules and state rules. So in Nebraska, a person can't have countable resources less than 2,000 and 3,000 for a couple. So typically a person, at least in Nebraska, if a person qualifies for even $1 of SSI benefits, they're also going to qualify for Medicaid, right? Which is another means-based tested program. The funds are provided from the federal government, but it's typically run through the state medical assistance programs. And typically each statute's going to have a statutory authority to administer that program. And so individuals, and especially children who qualify under state assistance programs or state disability programs, are also going to be eligible for Medicaid. Additionally, if you have a person who's in a Medicaid funded institution, but are maybe being cared for at home, those persons also may be eligible for Medicaid benefits. Sometimes you'll see also, for example, like aid to families with dependent children, veterans disability monies, subsidized housing. Those types of things are all going to be means-tested programs, okay? So once we've figured out what programs we either are currently on or programs that may be possible in the future, then we look at setting up a trust, okay? And the key factor, kind of like how we talked about in the beginning, is that, and I'm going to talk mostly about SSI and Medicaid recipients just because those are the most common. When we have a person who's receiving those benefits, then we can transfer any sort of structured settlement or inheritance, for example, into a trust so that the assets would not disqualify them from receiving their benefits. The trust option is important to consider because by placing it in this trust, Social Security says, okay, we're going to ignore those funds for purposes of means-tested benefits, okay? Especially where they have asset limitations, we can say, okay, we're going to have these not be counted for purposes of continued eligibility. Any questions so far? Everybody still with me, doing okay? Some of this can feel kind of humongous, I know it. So when we're looking at this next slide that we have here, when we're talking about special needs trust, there's two kinds, okay? So we have a first party and a third party trust. In some states, just kind of an FYI for you, some states do not allow first party trusts. So you'll want to check and see. Iowa and Nebraska both have them. Iowa has more recently allowed them. And so we'll talk here about the key differences, okay? So for a first party trust, and you'll see here where it says D4A trust and D4C trust, that just references the Social Security statutes that apply, okay? So sometimes if you're reading up on these and you see mention of a D4A or a D4C, that's what that means, is that it's the statute in the Social Security Act that references the ability to have these, okay? So under first party trust, we either will see what's called a self-settled trust or a pooled trust. they are always created by somebody else. So when you have an individual who is receiving funds, and here's a good example. Let's say that you have a disabled person, maybe a quadriplegic, and they are in a car accident and they are injured. That person is going to receive either through the court system a judgment against the guilty party, or if they would settle out of court, they would receive some type of a settlement for their damages, right? So let's say it's, I don't know, $300,000. Okay, well that's clearly going to be over any amount they would be allowed to keep in a if they're receiving Medicaid or SSI. And so we have to look at saying, okay, that's their money. They would otherwise be entitled to it. So we're going to look at, does a self-settled trust or a pooled trust make sense for that person? And depending on which one we would pick, the trust then has to be set up by somebody else. And then it's funded by the beneficiary with that money. So that $300,000 would be paid into the trust, okay? Under a third-party SNT, typically you're going to see these as testamentary trusts, and I kind of mentioned that before. So it's a situation where maybe mom and dad or grandma and grandpa would like to benefit somebody in their family who's on needs-based benefits. So they can set up a trust in their own estate plan that pays those funds to that trust once they pass away. It's created by them and it's funded by them. So it's not the individual's own money, it's the person who's benefiting the disabled person. So the key difference, right, in these two is going to be the source of funds. Are the funds coming from the person who is disabled, or are the funds coming from somebody else that wants to benefit the disabled person? Okay. So if you go to the next slide, we're going to get a little more in depth in terms of these first party trusts. So this is the first bullet here, 42 USC 1396, all that stuff. That's the Social Security statute that applies to these types of trusts. This is the language that says these are allowed, okay? In order for a special needs trust to be effective and for it to be allowed, the beneficiary of the trust has to be disabled under Social Security rules, okay? So they have to have already been found to be disabled. The beneficiary has to be under age 65 for a self-settled trust. So this is the person who received $300,000 in a structured settlement. In order for it to be a standalone self-settled trust, they have to qualify under these rules. The trust is then established by a parent, a grandparent, a legal guardian, or a court. So I've had cases where we've had to have the judge approve payment of money to a special needs trust, and that's perfectly legal under the rules. The disabled person cannot be the person that sets up the trust. The trust has to be irrevocable, meaning we cannot change it. We can't go back. Once we have passed go and collected our $200, there is no reversal. Okay, so under Nebraska and Iowa statutes, there are limited situations where you can apply to a judge to have an irrevocable trust changed. But in those cases, you're going to have the trustee involved, you're going to have the beneficiary involved. And typically, if they're receiving Medicaid or SSI, you have to have somebody from the department, from the state, who comes in and also approves the change. So it's a little bit of a hurdle if you're going to be doing a change to an irrevocable trust. So we want to make sure we get it right the first time so that we're not trying to make change.
For you there, Tasha.
Yeah.
Since that's irrevocable, does that mean you can no longer put more money into the trust? Just what's in it from the beginning is it, or?
Sure. No, so the trust can continue to receive funds.
Okay.
So like if you have a self-settled trust, we'll talk about in a minute though, where potentially it would make more sense to have it in a third party, but the trust can continue to receive funds. It just can't, the dispositional terms, so like,
Sure.
you know, when money is paid out and what it can be paid for and that kind of thing, it cannot be changed. That's a great question. The payback provision, so this is another super important point to kind of have in your toolbox here. If it's a first party self-settled special needs trust, that's kind of a mouthful, I realize, okay? And it's the disabled person's money. Medicaid requires that if the disabled person doesn't use all of the funds before they would pass away, that Medicaid is the first payback recipient for any benefits that they have previously paid for that beneficiary. So in our example where we have a quadriplegic who was in a car accident and they received $300,000, okay? And we put it in an SNT, and then let's say a year in, that person passes away and they have $200,000 left in their trust. Well, the Social Security rules require that $200,000 Medicaid estate recovery has a claim on that money for up to the full amount that Medicaid had previously paid on behalf of that person, if that makes sense. So if, let's say Medicaid, maybe the person was only on Medicaid for a month and maybe they only used $50,000, well then there would be $150 left, right? But if Medicaid had paid more than $200,000 over the course of that person's lifetime of being on Medicaid, potentially Medicaid estate recovery would receive all of that money back. Okay, now if the person who is the beneficiary of the trust utilizes all of the money before they pass away, then there's no money to pay back Medicaid, and that's perfectly fine. But the rules require that to the extent there would be money in the trust at the time that the beneficiary passes away, Medicaid gets first dibs on that money under this type of a trust, okay? As we've talked about, the self-settled special needs trust, first party trust, different names for it, it's funded with the disabled person's money. So in our example, the quadriplegic was in the car accident, he receives the judgment of $300,000. That $300,000 is his money, but we're going to divert it into the trust in order for him to stay on his benefits, okay? The beneficiary cannot be the trustee and cannot control the trust. That's another huge deal for Social Security. There has to be a separation between the person who is benefited by the money and the person who's making a decision to pay the money out or not, okay? So because the trustee is accountable to Medicaid and they're accountable to Social Security in order to make sure they're not paying out money that they shouldn't be paying out, okay? And last but not least, the trust is set up as a supplemental source of income. So the payment is made out of the trust to benefit special needs. So the trust cannot pay for anything that the means tested programs are already paying for. For example, it cannot pay for food. It cannot pay for shelter. Typically, it's going to pay for things like, the example I always use, it wasn't a trust that I did, but I was in an office with an attorney who worked on a case where there was a young man who was already disabled, and then I believe he was in a car accident. And so he received a lump sum settlement. And Medicaid would pay for bed A, because I believe he was not able to get out of his bed. He had to stay in his bed at all times. And so Medicaid would pay for bed A that had, whatever options on it. But bed B was way better. It was like the Mac Daddy of beds, right? So his trust could pay for the difference between the value of bed A and bed B. So Medicaid pays for bed A, and then trust says, okay, well, we're going to bump it up. We're going to give you an extra 50 grand, and we're going to get bed B. Okay, so things like that. It can supplement whatever is being paid for by the benefit. So you can get for people who are, if they're on disability but are still able to drive, I believe cars are considered an exempt asset. There's some rules on the value. I mean, you can't buy a Maserati, but you can get a car that you're able to, or like if you need some type of a van or something that has accessibility, extra things in it, that type of thing. Typically, the trust can pay for experimental treatment. So if you have you know, maybe there's some type of a medical procedure that Medicaid and Social Security are saying, no, we're not going to pay for that. Then the trust can pay for that separately. Or if there's like an educational program maybe that the beneficiary wants to do, if there's travel that the beneficiary wants to do, the trust can also help pay for, like, for example, if you have a beneficiary who cannot travel, but there's family that wants to come visit, the trust can help with that. You know, so the idea being that the trust is there to supplement the quality of life of the person who is otherwise disabled, so that they maintain their benefits, they're receiving their benefits under the programs, and then the trust can pay for supplemental things. Okay. And oh,
could it be used for education as well?
Yep.
So what happens if you
talk
receive funds for education to go, like, a college?
Like if they receive,
like,
well, so the question would be whether, like, if they got some sort of a grant or something.
Correct.
I think the question would be whether or not that you'd have to talk with the state agency, I would think, to determine whether that would be a disqualifying asset. You could potentially look at, we're going to talk about it at the end of the presentation here. I have a slide on enable accounts too, where you can potentially pay those funds to an enable account that are specifically designed for educational funds. So that would be another potential avenue that I would say to look at.
Yeah, so we have an enable account, and, you know, if tuition goes up, could this also offset it?
Yeah, I would think so. Yeah, the trust is designed to be able to spend money on educational needs and that sort of thing. So I think maybe we're asking two different questions though. If there's funds already in the trust or in the enable account to pay for education, I think that's fine. The question that I would have, that I don't know if anybody's ever asked me before, is whether if the person qualifies for some type of a grant through a state agency, whether that would disqualify any sort of benefits they're receiving. My guess is that there would be some type of provision in the, you know, typically those grants are going to have like program details or like a synopsis, right, that you can look at to determine whether whether it would be a disqualifying event. But if one of the requirements of the program, of the scholarship or the grant is that the person would have some type of a disability, there's got to be language in there that would identify whether or not it's a disqualifying event for means tested benefits. So that would be what I would want to know, is what does the program details for that specific grant or scholarship, whether it has language in there that says that. Is that answering your question?
Yeah, I think, you know, whether it's a Fed scholarship or assistance, or whether it's a scholarship that we apply for, we just need to kind of be concerned about.
Right.
I have a
right.
question,
That would be.
Are you
Sure.
able to have one of those enabled trusts that's designed for educational purposes in addition to one of these other special needs trusts for other things? Can you have both?
Yep. And the enable accounts have some restrictions in terms of the amount of money that they can have in them. And that's why sometimes they are, let me flip to my notes here on enable accounts. I believe the first 100,000 for enable accounts, it remains exempt from resource counting, but outside of that, so you can only have a maximum of 360,000. Hold on here. You can have a maximum of $360,000 in the account, but only the first 100,000 is considered exempt for resource counting for SSI and Medicaid. Oh, hold on one second. I got a crying child here. Hold on.
Yeah, I think we have a cap $15,000 a year that you can add to it.
I was just curious if it'd be helpful to have both. I don't know.
Yeah, so we have the Able account. It was set up as a UTMA, and then we switched it over to an Able account, kind of allowing more flexibility outside of college use. And so that could be for your quick expenditures, where the trust ideally would be for long term.
And that's correct, because the special needs trusts are not, they're not limited in terms of, I mean, you can cover educational stuff, but you can also cover medical, you can also cover stuff like that, whereas the Enable accounts are specifically designed for educational costs.
And the Able account, I don't know if it's like the UTMA, but you can move that over to a sibling if something happens.
Yep. Okay, I think maybe we're ready for the next slide here. So if you recall from one of our previous slides, under the self-settled trust, we either have a standalone, which is the slide we just talked about, or there are pooled trusts. There's some rules that are that govern these that are different from the self-settled ones, but also a very awesome planning tool, in my opinion, depending on largely on the amount of money that is going to be received by the beneficiary. So pooled trusts are set up specifically by statute. They are managed by a nonprofit. So they have to, and I don't know all the ins and outs, but I do know that they have to be approved by the state and the federal government. Like, they have to file all this stuff with the state and the federal government in order to be approved to run a pooled SNT. I believe right now, the only one that I know of, so I work in Omaha, there's First Nebraska Trust in Omaha has a pooled SNT that has been approved. I think maybe Lincoln has one too, but you have to specifically go to those entities that run them. So the pooled trust is basically like, we have this big pot of money and everybody has a sub account. So I like to use these in situations where maybe the person who is receiving the money, it's not a large sum of money. Because as you can imagine, when you set up a special needs trust, a first party special needs trust, there's going to be a lot of administrative expenses that go along with it. You're going to be, typically you want to use a corporate trustee just because they're going to be better equipped to understand the ins and outs and rules of distributing. And they're typically going to charge a fee for their distributions. For their management of the trust. It's going to have a tax return every year that it has to do, all of those types of things. Whereas in a pooled trust, the money is managed by the nonprofit, and so you pay just a flat expense that's shared by all of the people that have their money in this pooled trust. And the idea being that they're going to reinvest the funds so that your money hopefully is growing, and the amount of money that it's growing is going to exceed your share of the costs that you're paying administratively. So the sub-account is established by the disabled person, a parent, a grandparent, a guardian, or the court. There is still that same payback provision where if the person whose funds are in the trust passes away before they utilize all of the funds, it would go towards Medicaid state recovery, except where the benefits are retained by the trust and they're payable to a charity for the use of disabled individuals. So you can either have it go to that, almost like a charity, a gift, or it goes to pay back Medicaid state recovery. The funds in this situation, pooled trust can be used by individuals that are over age 65. and it's going to have the same limitations in terms of spending the funds on special needs. So we're going to be spending the funds on items that are in excess of what is payable by the means tested benefits that we are receiving. So the other type of trust that we talked about at the beginning here is going to be the third-party trust. And this is going to be a situation where we have an individual, such as my example, where I had the mom who came in and said, my son is disabled. If he receives all these assets when I die, he will be kicked off his benefits. And so we set up her estate plan to where when she would pass away, the funds are paid into a testamentary special needs trust. And we actually had her meet with a trustee in advance so that they could talk with her and understand the provisions of the trust, and you know, she could feel at ease that her wishes were going to be carried out. And so when she passes away, the funds will go into this special needs trust, and the bank will manage it. And the nice thing about third-party special needs trust, as opposed to the other two that we've talked about today, in a third-party situation, if her son would pass away before the benefits are all paid out, the money is all paid out, she can direct where the balance goes. And so kind of going back to what Skippy was asking earlier, if you have a person who has a first-party special needs trust, maybe you have a grandchild that has that, and you want to give money to their special needs trust when you die, it almost makes more sense to pay it to a third-party trust, because then if they don't utilize the money before they die, then you can have your other beneficiaries, other grandkids, other kids receive the balance, right? If it pays into the first-party trust and they don't utilize all the funds, Medicaid gets first stab at getting that money back. In a third-party trust, Medicaid doesn't have that claim because it was never the asset of the disabled person to begin with. It was a gift.
And when you say that they get first stab at it, you're saying that they are able to recoup the money that they've put out, not take anything above that, correct?
Correct. So they would have, Medicaid estate recovery has a claim against the beneficiary's assets up to the full amount that Medicaid has paid and no more.
Okay.
So if there's funds in excess of that, then the balance would go to other beneficiaries. But in a third-party trust, 100% of the balance goes wherever the person wants it to go, not to Medicaid. So that's kind of the key difference. So if you have a situation where you have, you know, maybe grandma, grandpa, or mom and dad, and they want to benefit the disabled person, but we want to make sure we're preserving eligibility, right? Because that's one of our key jobs. We can pay it to a third-party trust, and then the balance can be directed to other beneficiaries if it's not completely utilized.
Can I double check with you? You're indicating that Medicaid gets first dibs on what's left over, so to speak. What about SSDI?
So it's kind of the same. It's the same pool of money, right? So at least in Nebraska, and like I said, in different states it may vary, but Medicaid estate recovery is the program that is set up by the state to receive funds back once out of the pot of money that they've paid for benefits, if that makes sense. So it's
Medicaid under the time with SSDI as well.
Yeah, so Medicaid estate recovery is the department under the Department of Health and Human Services that makes claim to any funds that have been paid on behalf of the disabled person. And so you have to have that payback provision in your first party and in your pooled trust.
Yeah, appreciate it.
So if we go to, and some of this stuff we kind of talked about before, but if we go to the next slide here, we've kind of talked about this a little bit already, but the SNTs are going to have some limitations in terms of what you can spend the funds on. Food, shelter, covered medical services, and you can't do cash disbursements from the trust either. So these items, because typically these are going to be what the benefit programs, the mean tested benefit programs pay for at, as an eligible recipient of those benefits. And so you can't have a trust that's also paying for those same items, because the state and the federal government say, well, you're already receiving those things, so you can't double dip. So we classify distributions under a special needs trust under, the term special needs. And that's things like, for example, if the beneficiary is in a facility, typically Medicaid and Social Security, they'll pay for a dual room. And so then your trust could pay to upgrade to a private room. We talked about vehicles. If the person needs an automobile or a van for transport, the trust can pay for advocacy, accounting, legal representation for the beneficiary, non-traditional treatment or therapies that Medicaid says, no, we don't cover that. The trust can pay for those. Home furnishings, technology, entertainment. So we talked about travel. If I think it was the same case that I talked about with the young man who had the Mac Daddy bed. He really enjoyed playing video games. And so one of the things that the trust was able to purchase for him was a gaming system that his friends were able to play with him. And so he was able to have that interaction with his friends, where he had kind of a cool, system set up, right, that the trust was able to pay for to allow him, because that was one of the things that he was super interested in. So, the idea being that we have to make sure that we're following the limitations under the trust, because a distribution that's made in violation of that would potentially jeopardize the eligibility for benefits, right? And then if we go to the next slide here, we talked a little bit about enable accounts already, but we can touch on these again here. So they are allowed under Section 529A of the Internal Revenue Code. So some of you might be familiar with the 529 plans for educational savings that you can potentially use to pay for educational things for children. And the Internal Revenue Code was amended to include 529A to allow for funds to be held for educational uses for disabled persons. They have to be done prior to age 26. Typically, these funds, once the account is set up similar to an SNT, they're going to be exempt from consideration as accountable assets. And a person can only have one account nationwide. So from all sources, we can only have this one pool of money that's coming in. A maximum of $360,000 can be put into there, but only the first $100,000 is going to be exempt from resource counting. So you have to really watch the numbers depending on, the programs that the person is on to determine whether this is going to be a viable option. And I think, so maximum each year is $14,000, but I think it might actually went up, somebody in the group said, because it typically is going to mirror the gifting allowances for, because a person can give so much per year to each person tax-free, right, with no gift tax applied. So the money is considered
with Fidelity.
Yeah. The funds are tax deferred so long as it's used for qualified disability expenses, and the expenditures on non-qualified disability expenditures are subject to tax and penalty. And again, these are going to be potentially subject to payback provisions if, sorry, I'm just going to my notes here. If to reimburse state Medicaid upon the amount of the total medical assistance paid on behalf of the designated beneficiary. So if they're not utilizing all of the funds, then they're going to be potentially payable to estate recovery. The other option that is sometimes available for folks, you know, depending on all the factors to consider, is we look at doing outright receipt and distribution of the funds. So the Medicaid or SSI recipient may choose to receive the settlement and inheritance outright, becoming disqualified in the month that they would have receipt of the money, and then they would do a controlled spend down on the assets. They can spend it on exempt assets, like, for example, a house, a car, prepaid burial fund, $1,500 in life insurance paid up. And so it often just depends on the situation and whether that would make sense for that particular individual as a way to, you know, spend down the money. I have a case I'm working on right now where it may end up that the person does not qualify for disability. And so in that situation where the person is still concerned about asset management, which we talked about kind of at the beginning of the presentation, and whether that would be a concern for somebody, you know, having a family member serve as a trustee on a trust and paying the money, not necessarily to a special needs trust, but to a trust where we can control the distribution of the money to the person so that they have some longevity out of those funds. In that particular case, it's a young gal whose mom passed away and she's going to be receiving some life insurance. But she also has some medical conditions and they're still trying to make a determination of whether or not she qualifies for SSI. So, you know, I think the biggest thing is just doing research and doing the pre-planning, which several of you and all your good questions, it's clear that you're doing that. You know, because the more we know at the beginning, the more options that we potentially have to try to manage the money for the benefit of the person to get some longevity out of the funds. So that's pretty much all I have. I don't know if we want to have some questions or discussion about anything that we've talked about today.
Could the SNT hold the assets to a home?
Yep. So the issue comes into when we're looking at purchasing a house is whether or not other individuals will also be living there. Because if that's the case, then you have to look at what rent those persons should have to be paying. So, and there's kind of a complicated formula that I think different states use to determine what portion of the expenses for a residence would be covered by the beneficiary / trust, and what portion should have to be paid by the, for example, even if it's mom and dad, you know, if they're there, but if the trust owns those assets, technically Social Security and Medicaid is going to say, well, they've got to contribute, if that makes sense. So there is the ability to have property, but you've got to be able to show that it's not also benefiting people who are not disabled, if that makes sense.
Anyone else
So,
have any questions?
There was another question that's posed here about assisted living and nursing home. So again, it's going to be, the question is going to be, what program is the person on? Because if Medicaid is covering shelter costs, right, then, so in our example, we talked about where we had the person who maybe is in a dual room, right, and Medicaid is covering the cost for that. The SNT can cover the difference in order for your loved one to have a private room, for example. So we can't outright pay for medical costs or facility costs because that's going to be covered potentially under the SSI or Medicaid benefits. But we can potentially pay for those we can pay for those costs that are above and beyond, right? The quote unquote special needs stuff. So we're going to be paying for the better bed. We're going to be paying for the private room. We're going to be paying for the experimental treatments, those types of things. But for the basic shelter costs and food costs and medical treatments, that's typically going to be covered under those SSI and Medicaid benefits. And so by using a trust to pay for those, we would potentially lose our eligibility for those benefits. So, and that's why I think it's super important if we're setting up an SNT, you know, working with a trustee that's acutely aware of those rules so that we're not making disbursements from the trust that would kick us off our benefits, because we definitely don't want that, you know, because we're trying to preserve that eligibility. You know, it's kind of, I do some Medicaid estate planning with clients, and the application process is very onerous, as I'm sure some of you know. And you know, once we get on that program, it's great, you know, in terms of the coverage, because we have the ability to get a lot of services for minimal or no cost. And so preserving that eligibility is super important, because once we get off, then we got to, you know, kind of start that process over to get back on. So, but that's a great question.
All right. Anyone else have any questions? No? All right.
So thank you very much, Tasha. It was very interesting.